Ms. Macapella, you may be seated. Thank you.
Thank you, my Lord. My Lord, I confirm that the pleas are in accordance with the instructions that I have received from accused number 17. My Lord, we prepared a notice which we handed to the state that we were to file a plea explanation in due course. If I may please hand up the document that was served on the state yesterday.
Yes, please. Thank you. Yes, thank you. I take note of it.
As it pleases the court. My Lord, could I receive direction then, because we are faced with a bit of a problem. Our printed version of the plea explanation is on its way from the correspondent attorneys. Unfortunately, because we're based in Johannesburg, we have to liaise with our attorneys and then the correspondent attorneys. However, I do have my own handwritten version of it, which I may read into the record for time purposes. Or we could endeavor to have the printed version that will be signed by Ms. Chilota read into the record, as whichever the court directs us to.
Yes, when do you expect the printed version to arrive?
I understand that the partner of the correspondent attorney is currently in the regional court, and he's on his way to his office to retrieve it for us, or rather to make the copies for us.
Here in Bloemfontein? Here in Bloemfontein?
Here in Bloemfontein.
Could it perhaps happen over lunchtime?
It could, my Lord.
Because we are fast approaching lunchtime.
Indeed, no, it could, my Lord.
Yes. Is it necessary for me to enter this notice that you've handed up and give it a number? I don't think
It's not necessary, my Lord. It was simply to record that we gave the state reasonable notice of what we intend to do with the plea explanation.
Yes, can I hand this notice then back to you?
That will be fine. My Lord, and then just quite apart from the plea, could we receive direction with regard to the request that we made yesterday regarding our client's bail conditions? Will that be dealt with at the end of these proceedings?
Yes, we will deal with it after the pleas have been brought to finality.
As a court, please. Thank you.
I think for the moment you may read out. You say you have a handwritten version of the plea explanation. You may proceed to read that into the record, and then after lunchtime you can then hand in the typed version thereof.
Plea explanation in terms of section 115 of the CPA, read with section 108 of the CPA. The accused number 17, Ms. Nomalanga Murwadi Cholota, pleads not guilty in terms of section 106 1F of the Criminal Procedure Act, that this court does not have jurisdiction to try the offenses that she is charged with. In amplification of the accused's plea, in terms of section 106 1F, the accused avers that her extradition was unlawful. The state is put to the proof that the accused is guilty of the charges against her. The state is further put to the proof that the extradition of the accused was lawful. In further amplification of the above, and in terms of section 108 of the Criminal Procedure Act, the following issues are raised. 1. The state lied, alternatively misrepresented, to U.S. authorities that there was reasonable and probable cause for the charges against Ms. Cholota. subsection 1, she was charged after she would not implicate Mr. Magashule, accused number 13, in a witness interview by the state's investigators on 21 and 22 September 2021. 1.2. The state itself informed the Constitutional Court in a sworn affidavit deposed to by one of the investigators, Captain Carlis, that, I quote, "The fact that Ms. Charlotta did not attribute certain instructions to her former boss had the result that she was then treated as a suspect in relation to some of the same charges Mr. Magashule, her former boss, was facing." Full stop. Paragraph 133 of the third respondent's affidavit submitted to the Constitutional Court. 1.3. The charges against the accused was simply a follow-through of the threat the investigators had made against her that she would be charged if she did not cooperate with them. The state does not deny the threats or that they were made. They simply allege the threats were fair warning. The evidence will show that there was never a reasonable and probable cause for the charges and that U.S. authorities were lied to or misrepresented to. 2. The state lied or misrepresented to U.S. authorities that the accused number 17, Ms. Charlotta, was a fugitive from justice. 2.1. The basis for the request of the extradition, which is the surrender of a fugitive from justice, was that accused number 17 refused to or was not returning to the country to face trial. This information was proved to be false during the bail proceedings. 2.2. The magistrate De Lange found that there was no evidence that the accused had been contacted by the state and informed of a hearing date. 2.3. The magistrate also found that there was no evidence that the accused had been anywhere other than her university attending classes at all times. 2.4. The accused had demonstrated previously that she obeyed court or legal summons when she had traveled back from the United States to South Africa to give testimony at the Zondo Commission in December 2019. This was also confirmed by the magistrate in her judgment. 2.5. The state lied to or misrepresented to U.S. authorities that the accused was refusing to come back to the country and thus a fugitive and refusing to face the charges against her. 3. The state lied or misrepresented to U.S. authorities that Ms. Charlotta, accused number 17, was a flight risk with connections in Kenya. 3.1. The state prosecutor, Advocate Dinyeshan, deposed to a sworn affidavit under oath which was submitted to U.S. authorities. Therein, he informed the United States authorities that the accused was a flight risk and that she had connections in Kenya. Ordinarily, in extraditions, fugitives or accused are released on bail pending the extradition hearing. Accused number 17, Ms. Charlotta, was forced to abandon her pursuit of bail as U.S. authorities presented to the U.S. District Court that Ms. Charlotta was a flight risk with connections in Kenya. The magistrate De Lange noted this in her judgment at page 14, line 4, in which she stated, "The defense offered an explanation why they abandoned her bail application in the United States, indicating that there were false allegations made about her connections in other countries. This was not disputed by the state, although the state was given an opportunity to do so." 3.5. As a result, Ms. Charlotta abandoned bail in the United States as she could not defend herself against false claims that she had connections in Kenya. She spent 4 months in detention. 3.4. The state later claimed that it was mistaken that she had Kenyan connections and had only assumed this due to the fact that the accused had 3 layovers in Kenya while flying to other destinations. The US was never appraised of this mistake, nor of the fact that the Kenyan connection came from layovers. 3.6. In another affidavit under sworn oath, the state claimed that it had made a mistake because the accused has a child that is currently in Nigeria, and they mistook Nigeria for Kenya. This too was not appraised. This too was not informed to the US authorities. 4. The state lied or misrepresented to US authorities that the accused was part of a syndicate with Mr. Mbambani that facilitated kickbacks. On even the most cursory reading of the charges against the accused, what is patently clear is that the accused was never part of a syndicate. 4.2. No such allegations appear in the charge sheet or the evidence leveled against the accused. It is clear that such information was only given to US authorities to bolster their unlawful quest for extradition by any means, legal or otherwise. 5. The judgment of Yefer J in the case of Nomalanga Murwadi Selina Choloda versus the Director of Public Prosecutions and 2 others is instructive and warrants presentation before the court. Quote, paragraph 164. It can be taken as a fact that the information provided by the state had been incorrect. More importantly, upon the most cursory reading of the judgment of the magistrate Judge E. Aslan presiding over the extradition hearing, it is clear that the entire basis of the extradition proceedings was information that the state had provided on the applicant. The US did not conduct its own separate investigation or confirmation of the facts. It relied solely on the accuracy and veracity of the information given to it by the state. Paragraph 165. It is patently clear that the state is therefore to blame for putting this incorrect information before the court during extradition proceedings. The state should have made certain of its facts. Paragraph 166. I agree with the submissions of Mr. Makapela to the effect that the state would provide false or incorrect information to authorities of another country concerning a South African citizen presents serious public concerns and has serious implications on the interests of justice. I also agree with his submission that the above conduct by the state grossly infringes on international law and constitutional law. Close quote. 6. The judgment also dismissed the application, stating that the issues were issues that warranted attention of the trial court. 7. What appears pertinently clear is that it is undeniable that the state presented false and incorrect information on accused number 17 to US authorities. 2 courts, the Magistrates Court during the bail hearing, as well as the High Court in the Free State High Court, have already held this, full stop. The United States relied on this information in good faith and actioned the extradition on an unknowingly unlawful basis. The extradition is clearly unlawful. As such, this court is precluded from trying the offenses, as the unlawfulness of the extradition renders the jurisdiction of the South African Criminal Court void. End statement.
Thank you.
Thank you, my lord.
Thank you, Ms. Macapella. We will then wait till after lunchtime for you just to hand in the typed version of the explanation, and it will then be accepted by the court as Exhibit 5.
As the court pleases.
Thank you. Then we move on to the last accused, that is accused number 18. It's Margaret Ann Diedrichs. Thank you, she's present.
Thank you, my lord. The accused is charged with counts 1 to 8, that being fraud. If you may inquire from the accused whether it be necessary for them to be formally read.
Mrs. Diedrichs, counts 1 to 8 are also applicable to you. Do you know the contents and do you understand the contents of counts 1 to 8, or do you prefer the state to read them out to you?
No, my lord, thank you very much. I understand it is not.
Thank you. What do you plead to counts 1 to 8?
And its alternatives, I plead not.
Thank you. Thank you, Ms. Pearson.
Thank you, my lord. Then, if we may turn to page 62 of the indictment, namely count 20. This is contravention of Section 86 of the Public Finance Management Act, Act 1 of 1999, otherwise referred to as the PFMA, if it is necessary whether or not to put these
Yes.
charges.
Page again, please.
Page 62, my lord. Count 20.
Ms. Diedrichs, are you conversant with the count 20 against you? That is the count relating to the Public Finance Management Act. Are you aware of that count and do you understand it?
I'm aware of it and I understand it, my lord, and I plead not.
Thank you.
Thank you, my lord. The accused is further charged with counts 21 to 28 relating to money laundering.
(21 to 28).
Indeed, so, my lord.
Did you also have insight in these counts 21 to 28, Ms. Diedrichs, and do you understand? If so, do you understand those counts?
Indeed, that's right, I am aware and I understand, my lord, and I plead not.
Thank you.
Thank you, my lord. The accused is further charged with a further count of money laundering under count 73.
A further count against you, Ms. Diedrichs, is count 73. That is one of
Money laundering, my lord.
money laundering again. Yes.
Yes, I understand.
And
my lord,
and
I
what?
plead not guilty.
Thank you.
The accused is facing a further charge, count of money laundering, being that of count 74.
Are you also aware of count 74, money laundering?
I am aware and understand, my Lord.
Thank you, and thank you.
The accused is further charged with account number 75 of money laundering.
Do you understand count 75, also one of money laundering?
I understand.
And
my
you
Lord,
and you
I
plead?
plead not guilty.
Thank you.
Thank you, my Lord. The accused is also facing count 76, which is a further count of money laundering.
Does the same apply to count 76, Ms. Diedericks?
Indeed it does, my Lord.
Also the plea of not guilty.
Indeed.
Thank you.
Thank you, my Lord. As per page 66 of the indictment, the accused is further facing a charge of count number 84 of corruption in terms of section 3 of Act 12 of 2004, as well as its alternative of contravention of section 4 of Act 12 of 2004.
Yes, is that count 86?
80, this is 84 on
Okay.
page 66.
Count 84.
Count 84 and its alternative.
Is there only one alternative?
There is only one alternative, my Lord.
Do you know the contents of count 84, Ms. Diedericks?
I do, my Lord.
You understand it?
I understand.
What do you plead to that count?
I plead not guilty.
There is also an alternative to that count.
I understand the alternative and I plead not.
Thank you. Thank you.
Thank you, my Lord. Then on page 70, referring now to count 86, the accused is charged with corruption in contravention of section 3 of Act 12 of 2004, as well as one alternative in terms of contravention of section 4 of Act 12 of 2004.
Do you understand count 86 against you?
I do, my Lord.
And also the first alternative there.
Indeed, my Lord.
And what do you plead to count 86?
86 and its alternative, not guilty.
Thank you.
Thank you, my Lord. Those are all the charges leveled against this accused.
Thank you, Mr. Venter.
Good afternoon, my Lord. I can confirm that the plea of not guilty, in accordance with my instructions on all the charges as well as the alternatives, there will be no plea explanation in terms of section 115 at this stage.
Thank you, Mr. Venter. Mr. Rambau, do you have any further information?
My Lord, what has transpired during the break was to establish whether it would be possible for the doctor or the treating clinic to provide us with the details of the sickness that took the accused to be in the clinic. Unfortunately, it was indicated to me that in terms of the daughter-patient relationship, they are not permitted to do that. Your Worship, I do not have a problem, as indicated, that to provide the state with address of the clinic where they have to go and verify that information. And that can be made available to the state alone.
Yes. Can you perhaps tell the court whether this lady who is in hospital, whether she will be able to attend court on the Tuesday after
The long weekend.
the long weekend?
Indeed so, my Lord. When I looked into the medical report, the medical certificate, and verified it with the treating doctor, she is going to be able to be in court the week after the long weekend, my Lord.
The week after the coming long weekend.
Indeed so, my Lord.
Thank you, Mr.
Thank you.
Mr. Rambau. Then, as far as accused 17 is concerned, no, not accused 17, accused number 2. Ms. Mr.
Ethical position, my lord. It's Advocate Mhlanga on behalf of accused number 2.
Thank you, Mr. Mhlanga. Are you from Johannesburg, Mr. Mhlanga?
Indeed, my lord, I traveled last night and arrived residential night to be present today in this proceedings night.
I heard lately, Mr. Mhlanga, that you have now been briefed to represent accused number 2 in this trial.
Indeed, my lord.
But I was also told that you had other commitments in other courts.
Indeed, my lord. Based on what transpired in court here in my absence yesterday, and through communicating with my instructing attorney and client, I deemed it appropriate to put everything aside and preserve myself so that this court cannot be delayed in terms of what is happening, and also for the accused, who is represented by myself, can be properly represented in this proceedings now.
Yes, thank you, Mr. Mhlanga. That is appreciated. But I need to know, are you saying that you are now here to stay in this trial, or are you saying that for some periods you will have to disappear to attend to other commitments?
My lord, I can undertake that as current status stands, I am here for the matter, my lord.
Are you aware that this matter has been set down for this whole second term?
I have been indeed informed, my lord.
And you are willing to carry out your mandate for this term?
My lord, subject to certain issues being addressed and dealt with by the state, my lord. Firstly, my lord, as current matters stand, we were served with an electronic copy of the indictment of the docket, my lord, on the 11th. And since then, I've tried to peruse the docket. I cannot open the electronic version, and so therefore, as I have appeared before you, I do not have a docket in front of me. Secondly, whilst also making my preparations, and through the indictment that I got from the second accused, it appears that the indictment is incomplete. The indictment given to accused number 2 is incomplete, my lord. There's certain missing pages, therefore I'm not too sure insofar how far the incompleteness implicates accused number 2, which also then further affects his plea that he made yesterday. In that it would appear that that plea was made on an uninformed basis because there is no docket in front of us, nor there is a complete indictment that has been served on case number 2, my lord.
Any other issues?
The third issue, my lord, similarly with accused 3 and 4 and others, my lord, accused number 2 appeared before the State Capture Commission, my lord, and therefore, my lord, any and all evidence that relates to issues that were traversed in the commission cannot be used against accused number 2 in his proceedings, my lord.
Mr. Mshlangu, if you are now provided with documentation or the docket or whatever, if you are now provided with those things, will you be able to proceed with this trial?
My lord,
I'm trying to find out whether you want an adjournment, which you will not easily be granted.
that's exactly where I'm going, my lord. That is exactly the issue that I'm trying to deal with, my lord. Because as we currently stand, my lord, I don't have a docket. I cannot even prepare for trial in the short term, my lord, because there's nothing for me to prepare with, nor even advise my client with, my lord, in terms of the defense that we will need to put forward, my lord.
I see. I will take the opportunity to find out from the state what is now the position. Can I do so?
Indeed, my lord.
Thank you. Mr. Donation.
Yes, my colleague was here last Friday, as I told the court, and he appeared on behalf of the accused.
Mr. Mshlangu.
That is correct. And he told the court that he's not available this whole second term, but apparently that position has now changed. We did the same with him as with all the other legal representatives. That being, we asked them to bring a hard drive, compare the hard drive to our officers, and the whole docket and all the evidence and documentation is copied onto that hard drive, so that they don't have to pay per page for photographs, which would amount to thousands of them. Now, Mr. Mshlangu is now the first person that picked up a problem, apparently, because his documents doesn't want to open on his computer, on those files. But I was surprised to see him here this morning, and he told me about this predicament, and I found it strange. From last week in Friday until this morning, the state has heard nothing of these problems that he experiences apparently. So, why they didn't approach an IT specialist just to make sure that they've got the right software to read, to go into these files, I don't know. Why I was not contacted, I do not know. I've got an IT specialist available who can assist him if he just asks. So we can help him with that. But it's not a question of the state jeopardizing him or his client. He was handled precisely the same as all the other legal representatives, and I don't hear that anyone of them have got a problem. So, pertaining to the indictment, I'm not following precisely what he's saying, but everyone's got the same indictment. So, but we'll give him another one in any event. But again, why was that not addressed with us? Only now, for the first time.
Yes. Mr. Denison, I do not intend to sit here as a referee in the fighting between you and Mr. Mslangu. It's now lunchtime, and please, Mr. Mslangu, Mr. Denison, talk to each other, try and sort out the problems that are existing as far as you can, and then when we resume again at 2:15, you can tell the court what the position is, and then if necessary, the court will have to decide when this case will proceed, either Tuesday or maybe later. But please speak to each other. Court will now adjourn till 2:15.